counsel for the party present?
We are present. Someone will say.
For the prosecution?
The camera.
This is a ruling on the application dated 25th February 2019. I hope you can get me.
Yes, you can.
By this application, the applicant is simply seeking for custodial orders of respondents for a period of 10 days so as to allow them to do their ongoing investigation. This application is supported by the affidavit of one Corporal James Mwangi. In support of this application, the Petition Council only alluded to two grounds or reasons as constituting compelling reasons to warrant the detention of the respondent for the said 10 days period sought. And this were the complexity of the matter and an alleged witnesses' interference. The defense, on the other hand, vehemently opposed said application on various grounds, as can be summed from the submission section of the record. And the said submission can be summed up under one ground, that is, that no compelling reason have been advanced by the applicant to warrant the orders sought herein. I have carefully perused the said application that the affidavit sworn in support of the same. I have also given due consideration to the relevant submission tendered in support and opposition to this application by the counsel for the parties. On the first ground relied upon by the applicant, that is, complexity of this matter, the same is amplified by the amendment deponed to by the applicant in paragraph 12 in the affidavit in support. To this end, the applicant has maintained that they require communication data from several service providers which requires time. However, I do not think that this can be construed as a compelling reason at all, taking into account that the applicant has not deponed anywhere in his aforesaid affidavit that any of the respondents herein works for any of the mobile phone service providers. So I don't see any compelling reason on this ground. The second reason I rely upon is an allegation that respondents are likely to interfere with the witnesses. I wish to state that this submission was purely made from the bar, since the applicant has not deponed anyway his affidavit of such an alleged witnesses' interference. Consequently, I find no probative value in this submission, but for the sake of argument, assuming that this submission was amplified by the varnish deponed to by the applicant in paragraph 13, then I do not know how the respondent would interfere with the bank account in which in shillings 10 million in issue herein was deposited into. In any event, the applicant has deponed in paragraph 7 that the account in which this sum was deposited into is actually held in the name of one Ruben Nguna, who is not one of the respondents herein. It is not for this court to assume the likelihood of witnesses interfering, but for the applicant to demonstrate so in his own affidavit. Unfortunately, that was not done in the instant application. The following premises, based on those two grounds, which in my view the applicant failed to satisfy. If the applicant failed to satisfy, in terms of the mandatory provisions of Article 49, Article H of the Constitution, I find no merit in this application. I direct that the applicant, the respondents, all of them, be arraigned in court number 1 today in the afternoon for the offences as disclosed in paragraph 2 of the supporting affidavit, that is today for claims, failure of which they stand discharged. So go to court number 1, prepare your charges. You can have all the proceedings here in typed, certified for your purposes or for your appeal.
On speculation, and yet you're being asked for 10 more days on that speculation to keep these persons in custody. That cannot be fair. And so what do they do thereafter? They arrest these suspects and beat them thoroughly. I'm going to show you an example. This is the fifth respondent. Look at his right eye. This is the sixth respondent. Look at his forehead. This is the second respondent. Look at his hands. Yet the Constitution is quite clear that nobody shall be tortured under Article 25. Then what is that they are doing? So they are going to ask you to keep them in custody and continue beating them. Now that we have reported, we are in danger. In the light of that, Your Honor, can you even allow them one more day? Can they justify the reasons as to why they have done this corporal punishment on these people? But still, they want 10 more days. But Your Honor, it cannot be fair, even in Article 29, whereby you're supposed to treat these persons with dignity. If they can be beaten in police cells, if they can be dragged along the road, where is that dignity? And it's inherent. Somebody must be treated with dignity. It is there in the Constitution. It is not in vain. And still, they come for you 10 more days. Then they come and now tell you that because if they have failed in showing you what they have done, they must at least show you what they intend to do and why it is important that the suspects must remain in custody. But what do they have? They want to go and look for telephone data. Your Honor, your question was genuine yesterday. Do these people work with any data providing institution or any telephone company? No, they do not. So how is it important that they be kept in custody? The only other reason again is the bank. And you're being told there's a bank account. And so that we are clear on this, Your Honor, the investigating officer mentions one bank account for Ruben Njuguna, who is not here today. Why would he require them on Ruben Njuguna's account? Why? That is what he must give you. In his affidavit, he has not mentioned voluminous documents. He has not mentioned. Who does it? The prosecutor. Look at his application. He's the one who mentions it. If you look at the notice of motion, paragraph C and D, it is him who mentions it. This is not in the affidavit. Because if the affidavit has been brought to him, he cannot modify it, not today, not ever. So he modifies it by himself. On what law? On what permission? How did he get this information? This information only exists with the prosecutor and not the investigating officer. In the issues of saying that there is a complexity of investigation, number of suspects involved, in C, who are at large, involving through voluminous documents, including back documents. This is a creation of the prosecutor. So the person who needs to stand in the dock and give evidence is the prosecutor, not me. And he's telling me I'm playing to the gallery.
Yeah, I think we should. Please, I don't like your. I've tried to explain myself. I could hear you whispering things after counsel is submitting. Is it fair?
No, I was whispering to my colleague, not him.
And why are you whispering? Even from here I'm sitting, I can hear you.
My apologies.
You have your time.
Yes.
You respond to whatever I say. Even if you say stuff, let him speak without interruption. If there's any offending, I'll intervene.
You know, the issue that says that there is a likelihood of suspects and respondents here continuing with criminal activities does not come from the investigating officer. Again, it comes from the prosecutor. Again, then, where did he get this information? It is not on his affidavit. And this is why they tell you then that it is in the interest of justice that you keep them in custody. How can that be interest of justice when the prosecutor is the creator of these stories? If they want anything to do with the bank exists. They have not shown you how the suspects are going to influence the bank. But you are being told by the prosecution yesterday that it is a cartel, or the word he used was a syndicate. That syndicate, that cartel word by itself is not even in the affidavit of the investigating officer. So again, what interest does the prosecutor have in this matter? Such that if you then look at the application by itself, then apart from those two things that they want to go and look at, the data and the bank, what else is there, Your Honor, that you can call compelling? Because you'd expect that they'd be saying they are going to abscond, or they'll interfere with witnesses, that they'll have no fixed abode, that they will not come back to court. These are the things they're supposed to show you and compel you about. None of those exist in this application. And that is why, Your Honor, having shown you the injuries of these suspects, and then these policemen again are asking you for time, and the way they have, let me just say it, the way they even mentioned it to the investigating officer, took the money that was with the wife of the second suspect and took the money from the third suspect.
I object again, Your Honor. This evidence from the bar, this excitement from Mr. Ombeta, I don't get it. I object.
On the line of maybe
We can raise that then after we do that. But you see, Your Honor, my excitement is because I'm not happy with them. Sometimes you like them, sometimes you don't. You know, it's like a chameleon changing colors, and they look so good when they want to do public relations, but the things they do. But let me say it later. But when then they have been beaten like this, and this is why we are saying they cannot remain in custody, then this policeman, Your Honor, for lack of a better word, and I know Mr. Okello might want to react to this, are these policemen, when they do these things, or are they bandits? Because when you beat people like this, look, and not take them to hospital, and when they request to be taken to hospital, you disappear. These are not officers that you can want to respect, and yet we want to trust them to protect us. Your Honor, do not release these people to these officers, because we might not have anybody coming back here, not with these officers. I rest my case.
Yes, Your Honor. On a light note, I noticed my friend Cliff is catching feelings. But I'll limit myself to reply on what they've just stated. First of all, Your Honor, I think the respondents have completely misconstrued this application. Terribly misconstrued. This application under Article 49 requests further continued detention of the applicants, of the respondents, pending investigations. Now, if you come to Section 36A of the CPC, it details what we ought to do to convince the court to grant us these orders. You know, Section 36A of the CPC is very clear. First of all, right from the beginning, the reference that has been made by my learned friend, Mr. Shire, and she has referred you to 36A3. The requirement here, you know, is that the prosecution gives the general nature of the case and the evidence. It does not state that we are required to give specific details of that evidence. It further requires of us to state the inquiries that have been made in relation to the offense and further inquiries proposed to be made. In relation to the offense. And Your Honor, from the word go, and even at paragraph 2 of Corporal Mwangi's affidavit, he states that the DCI is conducting investigations into a case of forgery. The DCI has not decided that he has made up a case and is preparing to charge. And Your Honor, again, if you allow me, in common knowledge, and again, this is referred to again at the same paragraph 2, that a complaint was made, and the officer has referred you to the number under which that complaint was made. Evidence that a complaint was made. You don't need to have an OB to ascertain that a complaint was made. That is evidence of that complaint being made. And when a complaint is made, it is arising from that complaint that has been made that the investigating officer from that complaint can deduce what offense is likely to be charged and setting forth for the nature of investigations to be carried out. So that, for example, Your Honor, if I report to the police that I stole some money from you, that report being made to the police, clearly from the outset, we are dealing with a case of theft. And that is the land that is expected to be pursued. But it's only the evidence coming out of it that will eventually lead an investigating officer to the relevant offense to be charged. So these are still preliminary. And Your Honor, with the section 36A in mind, I just want to point out to you that we have enumerated what has been done so far. And this, Your Honor, is contained in paragraph 4, paragraph 5, paragraph 6, paragraph 7, and paragraph 8. What has been done so far? And then the officers are telling you what they intend to do regarding the nature of the investigations at paragraph 12, 13, and 14. So that paragraph fits in compliance with the requirements of section 36A. Your Honor, a lot have been said to you in the form of giving evidence from the bar. We have for you, Your Honor, the affidavit of Corporal Wanda. That in itself is an evidentiary document. That affidavit, it deposed to facts. Therefore, that being so, this affidavit has gone unchallenged. And it was very clear from the respondents, and they know that they ought to have responded to reply by way of an affidavit and counter those allegations. Why would they, before you, start giving you evidence, even of people who claim they've been beaten, they've been tortured? Where is that evidence before you? Allegations made from the bar by counsel. If indeed there were injuries, who knows where they sustained these injuries? Cliff, my good friend, knows me. He's not even mentioned this to me. So they want to convince you from evidence they've coined up, let me use his own terms. They've come before you with fabricated evidence. I do not speak to the president on a day-to-day basis. Maybe Cliff does. But what has been proved in this affidavit is that there's a certain telephone number that needs to be investigated further. That there are bank accounts that also need to be investigated. Am I giving evidence from the bar? The application is very clear that the prayers we are seeking are grounded on are based on the grounds on the affidavit itself that is before you, and those by the investigating officer in his affidavit. Those two documents go hand in hand. And I urge you, Your Honor, to so find and read them like they're twins. And Your Honor, I stated this yesterday. And from the line they took and their own admission, there are certain individuals that are still at large. And one they particularly mentioned, and is mentioned in the affidavit, and not before you in court, is Ruben Njiwa. Still at large. My friend Cliff suggests to you that what we ought to have done in indicating affidavit is the likelihood of the respondent to abscond. That is not the only requirement in this case. And what we are relying upon here, and what is germane here, is that they are likely to interfere with the investigations and the evidence that he has to be gathered. It's not about absconding. And again, Your Honor, you said it, and I don't know whether you made your mind about that. But it is our submission that you do not have to be a bank employee or be employed by a mobile subscriber for you to be able to interfere with investigations that are touching on you. And that is a submission and a stand that we stand by strongly. Now, certain submissions were made in Singa yesterday, which I find absurd. The suggestion, Your Honor, that we are interlopers, that we ought not to be here. And he has made reference and stated that it's this AG who ought to have been here. What does Article 156 say about the powers of the AG and the mandate of AG, as opposed to the mandate of the DPP at Article 157? The mandate of the AG under 156 is very clear, purely civil. I do not want to read it. He did not want to read it because he knows. The mandate of the DPP is so clear under Article 157. Anything criminal we are not here on a civil case. And we are not here to represent the police. We represent the state, the republic. That we shouldn't before you because the accused, the respondents have not been charged. My response, Your Honor, is that inquiries, investigations is a process. But then again, if you read section 157, Article 157(4), I believe, the DPP has powers to direct the IG to conduct investigations. So that the import of it, I submit, is that the DPP would be involved in this process even before suspects are arraigned in court.
I want to make an objection to the line that my colleague is taking. In my response, I did not go into the issue of the power of the DPP to direct any person. So he cannot revisit that matter. He's raising a new matter. But if he wants to raise it, Your Honor, it is fine. I would like to be given leave to respond to that issue and that issue alone.
No.
Your Honor, I would want a ruling for this, Your Honor. This is an objection. He has his position. He has his position, Your Honor. He has his position.
Can you let me conclude the question?
Yes.
I'm sorry, Your Honor, I think Philip's bag is getting to that height. Your Honor, yes. Your Honor, I'm responding to the issues raised. Sorry? Proceed with the establishment. Oh, okay. Thank you. Maybe he's trying to interfere with you. But how long time do you need? I think the next I think I shouldn't erase so many things, but I shouldn't take maybe more than the next 10 minutes. Yeah. I would be doing injustice to myself if I skip some of the issues raised, but just to finish with 157. Please, Your Honor, Article 157(4) is very clear that the involvement of the DPP would be even at the initiation of investigations. Yes, I'm done with that. Yes.
And again, Your Honor, the issue that was raised here about rumor. And that's the terminology we may choose to use. But we are talking about suspicion. The police arresting suspicion. At the time a complaint is made, that is what it is. And at that point, you can call it anything. But it is what initiates the investigations. So that the investigations will confirm or otherwise the complaint. And that is the point of investigation. And it goes on. So the issue, Your Honor, of rumors doesn't arise. In any case, Your Honor, they are the ones who are before you with rumors. Now, Your Honor, it is suggested under Article 143.
Your Honor, this application is requesting that you deny the suspects some liberty. But let me say that to deny any person liberty for even 1 minute, it must be given with very, very strong reasons. And that is why Article 49 in the Constitution was created. It is not in vain. It is not only there for show. Article 49 says that once any person has been brought to court, he shall be granted bail or bond with reasonable terms. Up to that point, it is our request. It is self-activating. We don't even need to come and ask for it. The prosecution are forcing our hand. So we shall reply. But the rider on that article is that they must come with compelling reasons, which the Constitution, unfortunately, has never given a definition. So we rely on the dictionaries, the thesaurus, the Oxford English dictionaries. When they define compelling, they say it must be something that is so strong, so forceful, so convincing that the court then must act. Unfortunately, this is not before you, so your task is very easy. When there is no charge in a case like this, it's imperative on the prosecution and the police to come to you and make this request. But they must fulfill 3 things. Apart from presenting the persons in court, when requesting for time, they must also show what they have done in such a case. What investigations they have carried out in this case. But so far, what have they done? They come and give you a long affidavit with a story that has been a creation. And that story is from one person called Naushad Merali. That is the story. Nothing else. So they have done nothing apart from listen to him. Yet, with that, they rush to you and tell you, give us 10 days to keep these people in custody. Can that be fair? Then, in trying to panel beat this application, paragraph 2 is then used. They tell you that they'll be charged with the forgery. You know, in part of what they are supposed to tell you, the investigations, is who has done forgery, where and when. What kind of forgery are we talking about? What exactly was forged? And what the investigation to that point has revealed. Again, I will say that is not before you. So your task becomes clear as we move on. Then you're told conspiracy to defraud. But they are just telling you conspiracy, not telling you who has conspired with who, for what purpose. Again, on that score, I give them a 0. Then they come again and tell you they'll be charged with an offense of obtaining by false pretenses. If you look at that affidavit and the application, none of this accused person has been mentioned as having obtained any money. Obtained, yet it's supposed to be a charge. So therefore, so far, what has the investigation revealed? They cannot rush to you now and tell you that is why they're asking for time. Note. Because it is by the same affidavit, that they tell you these suspects have been arrested from the 22nd until today. 5 days later, Your Honor, 5 days later, and they have nothing. Yet, they are not embarrassed to come and ask you, give us 10 days. For what? If they have done nothing until this moment. For what purpose? It is in that same paragraph that you will see that a complaint has been made in the CID office on the 21st of February 2019. You will notice, Your Honor, from that paragraph, it is a CID number that is given to you, not an OB number. So quite clearly, there is no OB, and the CID officers must be coining something. Again, and they are good at that. That one I guarantee you, they are very good at that. So then you're given paragraph 3 and paragraph 5, and you're being told these are the persons who have wired money. But the most interesting thing is paragraph 5. Actually, let me start with paragraph 4. The number is clearly shown. Whichever way they try to coin it, whichever way they try to avoid mentioning it, let's come to the truth. This number actually belongs to the president. It is a fact. I have it. I have been called and been tongue-lashed. It is a fact.
Your Honor, that is my objection. I think if you want to give evidence, don't show me. Come on, I'm here.
You have it here.
I'm here.
You have what?
If you want to take the stand and give evidence, please take it. Don't give evidence to the court from the bar.
Address the court. They don't address me.
Don't give evidence from the bar.
Address the court.
My objection is, Your Honor, I don't want you to go down. that is not the way to conduct the case.
Your Honor, this number is now being said it is a number that was used to call Mr. Mirali. Mr. Mirali then received the phone. This is what they are saying in the affidavit. And then, as a result of the voice that he hears, he asks for the money to be transferred. He must have been convinced that this voice belonged to the president. He must have been convinced. He could not have done it. This is a voice he must have heard before. So, to begin. So then, in as much as we might say Article 143 protects the president from any kind of prosecution, does it prevent him from being a respondent? In the absence of this affidavit showing you any
But then, it has nothing to do with his immunity. Investigation have been carried out. Whether or not there will be a requirement for the president to be a witness of note is neither there or here at the moment. And they cannot, they seem to be directing us to by stating that the president ought to have been here or to have been mentioned in the affidavit. Now again, the colleagues are going on and on, Your Honor, indicating to you the deficiencies in affidavit, which are